the repeal of Section 230.
Section 230 status.
Section 230.
Section 230.
Section 230.
Section 230.
Section 230 seems to be on everyone's mind these days, but what is the conversation all about? That's what we're here to discuss. Hello everyone, I'm John Mack Freeman, a speaker and librarian based out of the North Atlanta suburbs. I'm currently the Georgia Library Association's Intellectual Freedom Interest Group Chair and a member of the Library Freedom Project. Today we're going to jump in and we're going to talk about the Communications Decency Act. So let's take a look at what we're covering. We're going to look at three main aspects of Section 230 of the Communications Decency Act. First, we're going to talk about what Section 230 is, what it does, and where it came from. We'll also talk a little bit about how it has changed over time. Next, we're going to talk about a few things that Section 230 isn't. Many people in the media hold up Section 230 as a boogeyman that can solve all of the internet's problems. While it is important, Section 230 is often misunderstood or misrepresented by some politicians. Lastly, we're going to look at the numerous ways that people are suggesting to reform Section 230 to make it a better internet policy as we enter the 2020s. There's a lot to cover and we don't have a ton of time, so let's jump in. We're going to get started with what Section 230 is. Section 230 refers to Section 230 of the Communications Decency Act of 1996, which is a more common name for Title V of the Telecommunications Act of 1996. The law was passed in the wake of two legal decisions. The first was Cubby v. CompuServe in 1991 and Stratton Oakmont v. Prodigy Services in 1995. It's not worth going into the details of these cases, but basically what these two cases decided was that they formed a legal basis that companies that provided third-party hosting of content were liable for that content if they provided any moderation services whatsoever. So basically, if a content provider on the internet provided moderation around hate speech or took down defamatory content or content that was false provided by a third party, they were liable for all of the content on their platform, no matter who put it up there. This created an environment where companies could only be safe by moderating nothing or risking increased liability. Several members of Congress were concerned about the liability that this caused, and they sought a method for providing a liability shield for the burgeoning internet sector. Thus, Representatives Chris Cox and Ron Wyden proposed what would become Section 230, a carve-out in the law that would provide a liability shield for internet companies while also allowing them to do moderation services without affecting that shield. It was passed as part of a compromise measure with the Communications Decency Act. The rest of the CDA was struck down by the Supreme Court in Reno v. ACLU in 1997, so Section 230 is actually the only extant part of the Communications Decency Act that we still have today. So what does Section 230 say? Well, it really is not that long of a law, and the meat of it is in subsection C. So subsection C1 says, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. These are the so-called 26 words that created the internet, as Jeff Kosseff called them in his book of the same title about Section 230. And what this means is that it creates an intermediary liability shield for internet companies. They are not responsible or liable in a legal sense for any content that a third party provides on their platform. So if you post a review on Amazon, a listing on eBay, or any other of the massive amounts of content that users generate on services provided by companies, the company is not liable simply for hosting it. This directly fixed the problems presented by the Cubby and Stratton Oakmont decisions. The next part, subsection C2, says, in part, no provider or user of an interactive computer service shall be held liable on account of any action voluntarily taken in good faith to restrict access to material that the provider or user considers to be obscene or otherwise objectionable. Put more simply, computer companies and those on the internet can provide moderation services on their platforms without losing their liability shield. And there is no standard for what this moderation has to be. So long as they are acting in good faith, then companies can decide on whatever sort of moderation strategy makes the most sense for their company and their community. So between these two standards, we have an allowance of moderation, but not a requirement, and a liability shield that protects internet companies from liabilities from third parties that might be harmed by third-party content. So what does this mean? Once Section 230 was passed, it was still mostly undefined. However, it would be quickly put to the test in Zarin versus American Online. In 1995, Kenneth Zarin began to receive harassing phone calls at his Washington state home. He would discover that his phone number had been listed on an advertisement on AOL that purported to sell t-shirts celebrating the bombing of the Alfred P. Murrah Federal Building in Oklahoma City mere weeks after that event occurred. In the aftermath of the harassment, Zarin would sue American Online for negligence in not better policing its online services. The case was placed in the Eastern District of Virginia and decided by Judge T.S. Ellis III. Ellis found that distributors were a type of publisher as far as Section 230 was concerned, and as such, they were provided immunity from lawsuits and liability under subsection C1 of the law. Zarin puts forward a 3-point test of whether or not Section 230 immunity applies. Section 230 applies if the targeted entity is an interactive computer service, typically most things on the internet. The action against them would treat them as a publisher or distributor, and the content under question was initially provided by a third party. If you can answer yes to all three of these questions, then the subsection C1 protection applies, and the Zarin test, as it's come to be known, generally holds. While Zarin did appeal this decision, the Fourth Circuit affirmed the prior decision and the Supreme Court decided not to take the case. Because Zarin was the first case that was directly impacting the interpretation of Section 230, it really formed the basis of how most judges would rule on this law for the next 10 to 15 years. Section 230 has never been considered by the U.S. Supreme Court, but this broad application of the intermediary liability standard has been consistently affirmed by appellate courts throughout the country. Most court cases results in wins for the defendant internet companies. eBay has won, Ripoff Report has won, Amazon has won, MySpace has won. This is a very common defense that is put forward when internet companies are sued for content on their platforms. When we think about Section 230, we need to remember that it's all about liability. The biggest thing that Section 230 protects companies from is liability from inaccuracies, slander, and other lies that third parties put on their services. So this typically includes things like defamation, false information, sexually explicit content, failure to warn, threats, and terrorism. So this protects content that third parties provide in a variety of forms. Those messages could take the form of product reviews, sales listings, dating profiles, message boards, social media comments, and a wide variety of other content that internet content providers allow on their services for a third party to do. So long as the internet service company is acting as a publisher or distributor, as they typically are in these cases, the subsection C1 protection applies and they cannot be held liable for this third-party content. This repeated affirmation by the courts means that internet companies have felt free over the last 20 years to develop an internet where anybody can contribute content at any time. This is the law that has provided the liability shield for people to write whatever they want in a Yelp review or on eBay or to make listings on Amazon without these companies having to check the veracity and the truth of everything that goes on their platforms. Without Section 230, every comment made by anybody on a platform like Twitter or Facebook or anywhere else would have to be checked because there would be a liability for the publisher in putting this content out. That's clearly untenable with the way that the contemporary internet works. So Section 230 and the Zarin test provide this liability shield that has allowed the rapid development of the internet into an ecosystem where people collaborate and contribute without publishers having to get involved with approving every single thing that appears on their sites. So now that we have a better understanding of what Section 230 is, let's take a brief second to talk about what Section 230 is not. First off, Section 230 is not a law that demands platform neutrality by internet companies. One of the principal complaints coming from conservative politicians regarding Section 230 is the perceived lack of neutrality in the moderation policies of social media companies. As you'll recall from the previous section, there is no requirement for platform neutrality or a certain kind of moderation to receive the liability shield found in Section 230. Instead, so long as companies are acting in good faith, they can moderate their services however they please. Once again, Section 230 does not require platform neutrality. In fact, it does not mention neutrality at all over the course of the entire law. Another area that comes up sometimes in regards with Section 230 are conversations around hate speech and other disturbing content. Section 230 does not require any speech, or for that matter, any moderation of speech on behalf of internet companies or third parties. Rather, the more applicable law is the First Amendment of the Constitution, because that does protect the rights of individuals to express themselves even in morally repugnant ways. The right to free speech is a fairly broad right, and it does cover a lot of distasteful speech. Repealing Section 230 is unlikely to reduce the amount of hate speech and other disturbing content on the internet because much of this speech will still be protected in the United States by the First Amendment. All that Section 230 does is provide platforms the liability shield to do some content moderation. Without Section 230, there may be a reversion to previous standards where moderation would increase liability and thus might actually have the unintended effect of decreasing moderation and increasing disturbing content on the services that internet companies provide. So now that we know what Section 230 is and what it isn't, let's take a look at the various ways that people are talking about reforming Section 230. While this might seem like an obscure piece of internet law, it has garnered a lot of attention over the last 5 years, and as such, it has garnered numerous proposed laws that have not been signed into law, as well as one major change to the way that Section 230 works. FOSTA SESTA is the typical shorthand for the Stop Enabling Sex Traffickers Act and Allow States and Victims to Fight Online Sex Trafficking Acts of 2018. Passed with overwhelming support, this package of laws amended Section 230 to allow for a content carve-out of 230 protections for activities and content related to sex trafficking. It further allows for state attorneys general and federal civil enforcement related to sex trafficking. The law also changed some definitions related to federal sex trafficking laws and adjusted other parts of the U.S. Code to bring them into compliance with the new law. FOSTA SESTA was immediately challenged by several groups as being overbroad and vague, and some worried about the law stifling free speech or causing websites to step back from content moderation in order to maintain their liability shield through ignorance. While the outcome of the court cases around FOSTA SESTA are ongoing, they continue to be enforced at this time. This is the first time that the protections provided by Section 230 have been weakened by legislative means, but there are also many other proposals under consideration that we now turn our attention to. And while a lot of different bills might be introduced and Section 230 might be spoken of in a lot of different ways, all of these various reform attempts break down into a few key areas, and we can look at them one by one to look at the broad themes that come up in Section 230 reform conversations. The first is a full repeal. What this means is it would basically strike all of Section 230 from the U.S. Code. Proponents of this say that Section 230 has outlived its usefulness. It was written for a time when the internet was in its infancy, and now the internet is one of the most developed parts of the world's economy. And they're not wrong. When Section 230 was passed, the internet as an industry didn't even have a lobbying group. Now it is one of the biggest lobbyers in Washington. What this would mean, though, is that companies would be forced to remove harmful and illegal content or face potential criminal and civil liability at both the federal and state level. Repeal of Section 230 without anything to replace it would likely return to the jurisprudence provided by the Cubby and Stratton-Oakmont decisions from the mid-1990s, which, to review, is where the more moderation that a company provides, the more liable they are for all of the content that is on their platform. This was untenable in the mid-1990s and is impossible today in an environment where the internet is truly international and billions of things are added to websites every day. There is no content moderation team in existence that can monitor all of this content. And so we would be massively increasing the liability of these companies and potentially driving smaller companies out of the internet space. While some consider this to be a necessary trade-off, this is one of the more extreme solutions to fixing the problems posed by Section 230. The next area of proposed reform are what are called bargaining chip reforms. Basically, Section 230 protections would only extend to companies that follow a set list of protocols and guidelines. For instance, they would have to have transparent content moderation regimes or regular reporting. What these reforms aim to do is to make Section 230 protections a quid pro quo. Companies would still receive the liability shield that they have today, but only if they were to do some things that were in the public interest. This would require a new and fairly well-sized bureaucracy to implement and to ensure compliance. It may also incentivize the removal of protected speech as companies try to become compliant to maintain their overall liability shield. The next type of reform are size-based protections. What this would mean for Section 230 reform is that companies over a certain size would no longer receive 230 protections under the belief that these companies can now afford the content moderation necessary to safeguard their sites. Typically, the cap on this is put at hundreds of millions of users on an annual basis, or a market capitalization in the hundreds of millions, if not billions of dollars. This would increase the cost to internet companies to grow beyond a certain point. And so, in essence, it would penalize success because only those companies that were at the height of success would be subject to the loss of their liability shield. While conversely, proponents in favor of this argue that these companies that have the broadest reach, the Googles, the Facebooks, the Amazons of the world, are most likely to shape society and thus need to be held accountable more than smaller and more niche services. My biggest problem with size-based reforms is that it fails to account for companies that blow up quickly with little time to scale their content moderation services. We can especially see this in social media platforms that become popular with younger people. You can look at the quick rise of things like TikTok or Clubhouse or Snapchat from various years over the last decade to see that oftentimes companies scale at a much faster rate than they initially expected. So removing their liability shield once they reach an arbitrary point may do a disservice to the way that the actual internet economy works. The next type of reform is what's called a notice and takedown reform. Services would have to provide a method for users to submit content for review that they consider to be a violation. Upon notice, companies would have to take action to review and take down offending material. This is very similar to the way that the Digital Millennium Copyright Act works, or the DMCA. If you've ever seen something removed from YouTube for copyright violations, that's generally the law that's being used. This is somewhat similar to the European model, where if companies are informed about defamatory content or false information that is on a website, it becomes the liability of that website to remove that content. It does increase the size and complexity of compliance costs because you would have to have a team in place at every company that hosted third-party content to review these complaints and to see which ones were valid and which ones weren't, and to provide responses back to customers. However, Notice and Takedown does have the positive side that it provides a direct way for consumers to interact with companies that are often faceless and distant when they have a problem or when they're being harassed or when their information is being misused. The last large trend in Section 230 reforms is just to do nothing. Proponents of this say that Section 230 has contributed to an ecosystem that has led to the fastest development of an industry of value in the history of the world. And they're not wrong. The internet industry and the social economy online is incredibly valuable and an incredibly rich resource for a large number of people. And there are a lot of large invested interests that want Section 230 to remain as it is, and there is major lobbying pressure to make sure that this law stays in place as a huge liability shield that only this particular industry gets. So while there is some promise that if Section 230 doesn't change, that internet companies will continue to be able to develop as they have in the past, that also means that we get the internet and the society that is built around the internet that we have today, with all of the problems that the internet has brought us over the last 25 years. While the internet has brought a lot of good into society, I don't think that anyone would argue that it hasn't come with some bad. And so some reform of Section 230 is almost certainly necessary to deal with the evolving landscape that we find ourselves in. There are a few other minor proposals or tweaks that are worth mentioning. So some want to talk about expanding federal, criminal, and or civil enforcement, removing the or otherwise objectionable clause from subsection C2, exempting state criminal law from exemption, or establishing binding industry standards that companies must follow. Oftentimes, these are wrapped into proposals from the larger types that we covered previously, and they don't address the main thrust of the problems that people express around Section 230 and the liability shield. So where are we headed? Section 230 is a very important law. It affects all of us, even if we've never heard of it before today. So what do we need to do to fix it? Well, everybody's going to have their own solution, and everybody's going to have their own method for approaching that that's going to be different based on where they think the biggest need is. In my case, I think that there's kind of a three-pronged approach that we need to take when it comes to reform. I think that we need to include Section 230 in discussions of intermediate liability with other discussions around net neutrality, broadband access, and other general internet regulation. The internet as the Wild West, where there are very few laws, is a time that needs to be quickly fading in our rearview mirror. Because this is a new marketplace and a new land where everybody lives a good chunk of their lives, more regulation is necessary to ensure equity of access and equity of opportunity for everybody that uses this platform. I also would argue that we want to make the internet a public commodity like power or phone service and place the FTC in charge of it, so that there can be a regulatory body that can speak to these issues and that can make minor tweaks as the industry changes or as time goes on. I would also suggest a legislative reform of Section 230 that's a combination of multiple bargaining chips that encourages more robust and transparent content moderation by internet companies in return for a liability shield that may not be as robust as what exists today, but that is far from leaving them to the wolves of an endless amount of nuisance suits. I want to thank you all for taking the time to view this video today. If you want to continue this discussion or talk about Section 230 more, you can reach out to me at johnmacfreeman@protonmail.com or visit my website at www.johnmacfreeman.com. I hope you have a fantastic ALA, and I look forward to seeing you in person in the near future. Thank you.